and matters arising?
Yeah, so the first is I share his lawyer's sentiment.
Why?
Yeah, because you see, when he says there is disrespect to the court, it's because there are pending proceedings. You see, there are pending proceedings. He filed for stay of execution, right, which is before the court. And you see, in law, the other lawyers here will tell you, in law, we have this principle that, you see, generally, once proceedings are pending, there's a general principle of contempt that don't do anything that brings the proceedings or makes a mockery, right? That brings the administration of justice into disrepute. So listen, we all know that, let's speak straight to the facts and then speak candidly. We all know that someday, somehow, it is possible that they would have extradited AbuTrica. Okay,
that was definitely going to come.
You know, we're hoping to delay it as much as possible until OforiAtta is also brought, or so that, or we do an exchange. At the time we are handing over AbuTrica and Daniel Yusuf and co, then we are receiving OforiAtta. So as for extradition, it wasn't a problem. The only problem is that OforiAtta is not coming early. So my point is that once there were proceedings, but this is not the first day we are making that point. So once there were proceedings before the court, you don't ignore the proceedings and take him. So it's contemptuous of the court. If Oliver chooses to file, there will be trouble. Once there are proceedings, and listen, it doesn't even matter that you are not aware. If you are not aware that there are proceedings and you do it, what it does is that's when I say you do it, that's you, excuse me, you undertake any conduct that renders the proceedings a nullity. Because when he says he wants stay of execution, etc., it means that don't send him yet, don't extradite him yet. And it doesn't matter. That's why I say it doesn't matter that you know that, the judge will throw this thing out. That's not an excuse. Wait for the judge to throw it out. But it's not for you to look at it and say, this thing is so porous, it's so weak, banal, it will be thrown out. So ipso facto, you are sending the person out. No, we have a lot of decisions. In the second republic, under 69 constitution, there was a minister of interior, Dombo. This Olympian matter. Dombo was convicted of contempt. Straight. Or, well, sometimes you say we shouldn't use the word convicted because it's not a criminal offense. So maybe we can say was found liable or committed for contempt. Now, it's not a criminal. But it's not the same as criminal. It's not a it's not, you don't get a criminal conviction when you are committed
and sentenced to serve.
Yes, but it's not it's not a criminal offense. So you better say committed or found liable in contempt. Dombo, Minister of State, and in it the court made it clear that the fact that you don't even know that there is a court matter concerning what you've done is not an excuse. It doesn't mean that you are not liable in contempt. You'll be found liable, but when it comes to the punishment, because you didn't know at all that there was anything in the court, then perhaps that's when they will give you a warning or a fine, something small. But in this case, the Attorney General had been said that in this case, if Oliver is going to file contempt, it's not only against the Attorney General. It will involve my good friend Okujeto, the Foreign Minister, because we tell you extradition is a political matter, and even President Mahama, all of them. But then you begin to see that, hey, do you want to cite all of them for contempt? It will begin to look a bit unwieldy. I say so because I remember, you can ask Afenyo Markin, the time Chief Justice Wood was a Chief Justice, there was something President Mahama did, and then I think a pending proceeding, and then the government took an action. I think Markin said, I will cite them for contempt outside. The Chief Justice Wood said, Mr. Markins, I advise you to think carefully about this thing.
Yeah, you could do, but whether you could realize the same results is another matter.
I always remember it. Mr. Markins, I advise you to think carefully about this result. You are bringing your president to court for contempt, etc. I don't think Afenyo Markin did it this filing. So I think that must have been 2015 or 2016. Yeah, I remember it being in court that day. So, but it's very shameful. It's a shameful thing. No, the government shouldn't have done that. Wait, what's the inordinate rush? So the point is that, is there a loan we are looking for from the US? When you see this inordinate rush, it means that there is something we critically need from the US at this point.
Is that so, your reading of this?
Yes. When things happen like this, where there's a matter pending before a judge, and you know that Ghanaians have become very savvy. They become savvy. Why this inordinate rush? So let's look and see what loan. The first thing you'll be thinking about is maybe government needs a loan Because to do this, to disrespect our court. It's not. It's analysis. I'm allowed to. No, you don't call it. It's an educated. This gets based on the way governments.
What I want to find out is, you say that the end objective of the extradition was definitely going to happen.
Most probably. As I said, provided they brought down OforiAtta. Then,
yes, so your issue was what we were going to, or what we were going to get in return.
Absolutely.
So why don't we just see how the coming days will look like? See what we're going to get in return.
OforiAtta is not coming within the next 6 months, right? It doesn't look like it because it's not even attended court once. So we don't even know whether. Look, in actual fact, let me tell you some of the things. The things we took there when we talk. The OSP charges, Americans have said it, that the charges don't look good. They don't look good. Yes, they don't look good. So we are now suturing the charges, trying to put them together, etc. Why I say you should resign, you don't understand. You can interview him. When we sent the packet, he said, these charges you said, they are bogus. Ask Kisi Ejabi, interview him. So they are now trying to help suture the charges, do things. So OforiAtta is not about coming. Of course, though, you see, but when they say the things are bogus, it's not that I'm supporting the Americans. No. Okay. It can be a ploy to delay his coming. Because remember that OforiAtta has, what do you call him? Danny Ashcroft. Okay? Johnny Ashcroft is a lobbyist. So, you know, there are various ways of killing a cat. They can intentionally come and say, oh, your charges don't look good. Bring this, bring that. Dilly-dally. Dilly-dally, sir, before you realize 2 years. Then to say, your charges don't look good by our law. So we're trying to help you. So on the face of it, because the reason I'm saying that that's not a good reason is that, look, when U.S. interest is involved, when it suits them, they will just pick OforiAtta and bring him to us. Have you heard the word rendition? Rendition is the cousin to extradition. When they see the extradition is too difficult, what they do is rendition. They'll just pick you, bundle you, and bring you. Many from Afghanistan, Syria, those. America has rendered many people. You can Google and see the literature on rendition. I'm not supporting it, but I'm just saying that the reason I'm bringing it is that rendition hasn't stopped. When the U.S. finds it suitable to their national interest, they will just render you. They will just pick the person and bring him. They don't care about extradition when their national interest is involved. So they say that our charges don't look good, things are missing, this, so put this here, correct this, do that. It can be a ploy because as long as rendition exists, if it were the case that the whole world has now accepted that rendition has been outlawed, no country can render any person, then I would believe them. So as long as there's rendition, meaning that in this case, if they were to render OforiAtta to Ghana, everybody will be happy because, why is the man hiding behind Johnny Ashcroft, the lobbyists, etc., to delay? That's what they're doing. Then they say, oh, go and amend this, your charges. Your charges have issues. This is missing. This is... No. I know. Yes, that can be there. But I'm also saying that it can be used as a ploy to delay his coming.
Right.
So far from what we're saying, OforiAtta is not near going to court. Because now they are suturing, when I say suturing, sorry, I don't know what I'm just saying. They are trying to tidy up, trying to amend the charges, tie them together, sew them together, and prop them up. That's what they're saying. But as I said, let's be careful. We cannot totally accept that. As long as there is rendition, they can render him. They can render OforiAtta to Ghana.
So that's another
it's an option
we can use. Okay.
Yes, Alfred. Number one, I don't agree with my good friend who says that extradition was a matter of fact to happen in only a few days. Except that they ought to have waited for the process to be taken in court before. I agree with you that the process ought to have been taken before, but nobody could determine the fate of that process for us to conclusively say that he was to be extradited by all means. No, I don't agree with that one. So I think that it is true that when the process was before, probably before the same court, then I don't see why the process was not taken before the action that ought to have followed the determination of that process. I don't know. Probably it was not before the same court. Probably the court was not seized with information of the pendency of that process. So we will excuse the court if the court made orders without knowledge of a pending process before the court.
Let's correct this.
But if it was
let's correct this. Let's correct this. You see, the extradition order, all right, it's made by the district court. It's not the high court.
Yes.
So that order was made by the basic district court some months ago. So to go out, it's not a high court.
From basic.
Yes. So let's just straighten it so that to make your argument stronger. So the district court, okay, made the order that it should be extradited some months ago.
Right.
Then Oliver rightly went to the high court and got bail. So it stultified it.
And
so,
will this come first in the application for bail?
Yes.
To the knowledge of that court?
Yes. So, of course, you show the judge evidence that he's been, there's an order, he's been committed to be extradited, blah, blah, blah. So the High Court, Alawa, Bassett, Justice Alima, right? Bassett.
Granted the bail.
Granted the bail, and that's good. It strengthened our system, okay? Then, some months later, you know, the Attorney General was hauled to the U.S. That's why I say he was summoned to the U.S.
He was hauled.
Yes, let's say it. Look, we are not joking. We are not Iran.
Do you know that he was hauled? Or there was
Yes,
a visit?
we have
Because
to
I
put
know
it strongly. Then you will see that there's some. You see, we are not angry enough. Look, this is a very serious matter. Matters pending before our courts, and yet you have our government extradite somebody. So it tells you that there's some force at play, something that's overwhelmed us. So let me just quickly. It helps. This is the fact. So the judge granted bail. Then fast forward, when the AG returned from the US, as I said, I don't know what we are getting in return. Then quickly they brought back the case to the court. Then the judge revoked the bail. Then Oliver now files again to hold the bail. So that's a stay of execution, blah, blah, blah. So that is what is pending. So the judge has revoked the bail, meaning that now you can take AbuTrica to the US. But Oliver is filed process, and that is what is pending, and then still. So this is a rendition. What Ghana is done is not extradition. This is a rendition.
Let's go to the process.
That's what you disagree with.
Let's go to the process.
Yes.
Okay.
Pursuant to the refusal of the bail or the failure of the bail application, whichever is the case, was there any appeal against that decision?
Exactly, all of those.
Was there an appeal against the decision?
That's what I'm saying. You can put Oliver on.
That will situate the stay of execution.
Oh yes, basic, but that would be basic.
Right. Okay. Yes. If that was the case,
yes.
If there was a stay application pending, had not been taken, then one would presume that it ought to have been taken before the next activity of the extradition.
But was there a stay of
Yes.
execution?
Yes.
Okay, that's
yeah, and you can put Oliver back.
I'm qualifying all my presentation. If there was, then of course procedurally it was wrong for us to have gone ahead without considering the pending application. So that one I agree with you. But again, I'm not also in agreement when you say that there was a package, a return package for which we were influenced to take the action we took as a country.
Oh, absolutely.
You see, you don't need any motivation beyond the determination of the various courts to do that which was done. So I am not in agreement to say that.
So you breach your own laws, disrespect your own courts.
Please,
for nothing.
Please. I will not make a submission that I cannot justify. That there was something, the package waiting for Ghana. For his region, we had to do that. I don't know about that. I cannot.
I know about that.
Well, so inform us. Let us know what American government had put in place for us to justify the.
They call it quid pro quo. That's their word.
So if you don't have that information, in fact, in the year in 1983 thereabout, some Ghanaians were also extradited.
Susudis.
And in return, we had some Ghanaians also extradited to Ghana. So that is a possibility. But I'm not aware of any such package now which will justify any such action. So I cannot speculate like that.
Don't call it speculation, please.
He doesn't know what you know. So
you see, and again, the district court would have granted that order to extradite. And you know, it is a possibility within our laws. And indeed, we in Ghana, we also have the Extradition Act of 1960, which is still in operation. And there are only two conditions that we need to satisfy for the court to make such a determination. And one of these is that whether or not we as a country, we have any such arrangement with the requesting country. And in this case, the answer is yes.
Yes, we do.
And whether or not it is not a matter affecting a political question. And the answer is no. And in any case, if we have satisfied these two preliminary conditions, then the court, and if there has been also an order from the receiving jurisdiction that there is a request for extradition, when these three conditions have been met, then the court would not normally, ordinarily, accede to the request. So that is what was done. The only hinge about the process is the pending application, which I agree with Martin. So it could have. And again, I say that did that come to the notice of the court, of the High Court? So the High Court also haven't taken any decision in that. So if the district court was seized with knowledge of a pending application like that, then probably it would have withheld the request. Again, even if the request was granted and the action had not been taken, the Foreign Affairs Ministry would have said that, well, let's hold on, because he was in lawful custody. So let's hold on until this one is taken. And then in respect to our statutes and also in respect to our judicial system. So that one, I agree. There was no need for any rush. In any case, I'm not saying that the court was wrong in accepting the extradition request. Yeah, it was in order. And again, we have this arrangement. And again, the question is not a political question. So personally, I think that nothing has been done. And in any case, I agree with Martin again when he says that the extradition order and then the extradition itself does not constitute any offense or any crime or any acceptance of commission of crime. So what we need to do is that he should be given the necessary opportunities and time to prepare his defense. And here, what I will advocate is for him to be given proper legal representation, for him to be able to defend himself.
As far as we do know, that is actually being done.
And again, in this case, at the expense of the requesting country. So, and don't also let us forget that he has a right to determine who represents him, even in the jurisdiction that he is not familiar with.
True.
And the state of the United States should give him the opportunities to also select the representation that he has confidence in, and also the cost of such representation be borne by, because of course, come to think of it, until he is proven to be guilty, he has not done anything.
I really think it's about the integrity of extradition. It's about due process, judicial authority, and ultimately Ghana's authority. Because although I do agree with what the State Department said on the 17th of June, when our Honourable Attorney General went over, that this is a shared commitment to fight fraud, cybercrime, and transnational and organised crime. As you know, the representative from the U.S. State or the U.S. Department in Ghana said, we've had 9 extraditions in 1 year alone under the current administration, and it's an extraordinary achievement, he said. And he also mentioned about upholding the rule of law. And in upholding the rule of law, it's also about, the date of him being committed to prison to await his surrender, because from that date, he had at least 15 days to do a habeas corpus application. And so if that date counts from the 2nd of July, then he had technically up to the 17th of July, and yet he was in US territory pleading not guilty to federal charges on the 10th of July. And as my learned senior said, lawyer Martin Kpebu, that, we all know that quite possibly very likely he could have been extradited. But the period from, the 2nd of July to the 17th of July wasn't that long. And what was the rush if we are so sure about due process, etc.? And at that habeas corpus review, for instance, 3 questions would have been asked: the identity, the jurisdiction and authority, and the probable cause. And of course, if his lawyers couldn't answer those questions, he would be on a flight. But I definitely don't think we should just rubber stamp these foreign prosecutions as easily as we do. If we look at countries such as even Sierra Leone, for instance, there is layered stages to even extradite. And, I think even the Attorney General can independently say no, et cetera, et cetera. So just like in America, it takes at least 5 years on average to extradite a person. And if they, for instance, don't object to being extradited, they come back in 2 years, as we saw with the lady who just returned recently. So I definitely think it's about the integrity of our extraditions. It's not about defending fraud or anybody committing fraud. And it's also Ghana sort of taking a slightly higher ground in terms of, I do also agree with lawyer Martin Kpebu in what he said about, is this quid pro quo? Because all of a sudden we had an MP sitting in the Netherlands and the nation was in uproar. The politicians from the NDC side seemed to be in uproar, and we said we were going to hold off on these extraditions until we saw like a 2-way stream. And after the 17th of June, meaning after the Attorney General went, he said to the press it was an amazingly good set of meetings, amazingly good. So we take from that as educated lawyers, and that's why Martin Kpebu was speaking as he did, that something came out of those meetings in terms of quid pro quo, et cetera, be it for extraditions or be it for some sort of financial gain to Ghana. But in all this sort of quid pro quo territory, we can't be looked at as just having absolute submission to US authority when we do have due process. We have our own laws, we have our own judiciary, and it's about the integrity of extradition. And as I keep on saying, from the 2nd of July, when that final decision was reached, to the 17th of July, which is a 15-day period that is in the Extradition Act, Act 2022 or Act 22, what would it have hurt to wait to at least the 17th? But right now, we've got a Ghanaian citizen pleading not guilty on the 10th, and there's absolutely no way of reversing it. But we could have waited, I think, until at least the 17th. And as the FBI is also being very, and rightfully so, cybercrime and transnational crime and organized crime is huge, and they must send a message that they will pick you up anywhere, and they should. But also, with the FBI, it's also about how are they dealing with the Epstein files, for instance, because that also involves transnational organized crime and money laundering and extortion and all sorts of things in relation to blackmail. They were using a lot of the tapes on the guys to blackmail them, et cetera, and yet not a single person internationally or within America has been picked up by the FBI with the Epstein files, except one woman who is in jail, et cetera. So not that we're measuring the Epstein files against something like this, but when you look at the bigger picture, it's not just about picking up these cyber criminals without complete due process on our side, but looking at holistically how everything sits together. And ultimately, it's about our sovereignty, and it's about due process, and it's about the integrity of our extraditions, first and foremost, I think.
Reading this piece you shared with me, and there's one part which I just want to separate the issues. You say this is not about defending fraud, that Ghana must never become a hiding place for people accused of romance fraud, cyber fraud, money laundering, or any form of transnational crime. If a person has a case to answer, then they definitely would have to answer.
Yes.
But your issue is with the extradition, why do you say it's not supposed to be automatic? What do you mean?
Because as the representative from the U.S. State Department or from the U.S. Embassy that just spoke on the show, in terms of the recording you just played, as he also said, it's about upholding the rule of law. And so in upholding the rule of law, we're doing this so we uphold our rule of law because we have sovereignty and we have due process and we have judicial authority and we have the integrity of extradition. So for instance, if that 15-day window, started from the 2nd of July, for instance, that's the date of him being committed to prison to await surrender. Ghana's Extradition Act under Section 7, I think, says there is a 15-day protection window from that time. So that would have run out on the 17th of July, and yet we find one of our citizens pleading not guilty on the 10th of July on US territory. So it's all about sovereignty, it's all about due process, and it's all about if we only had to wait to the 17th of July for a judge to, rule on a habeas corpus application, whether she agreed with that or not, why couldn't we have waited to then? It's not a long period to the 17th of July. And so we can't enter this slippery slope because, as the US representative also said, it's extraordinary that under this government, we've had 9 extraditions. And I think the last government in particular, they were approached about extraditions, et cetera, but first and foremost, it's always about, this is a Ghanaian citizen, do we so easily extradite? And if so, let us put some hurdles in. So that's my argument, really. The integrity of the extradition, due process, judicial authority, and Ghana's sovereignty, because a Ghanaian passport means something. So if we only had to wait to the 17th of July, what was the rush and why did it need to be done so quickly?
Amanda, thank you very much, Amanda Clinton, for this. But due process, the integrity of the extradition and Ghana's sovereignty, essentially. But it did not happen in a vacuum. This is the law that provides exactly what happened, the legal framework that guided what has happened regarding AbuTrica and others who have been extradited. The Extradition Act 1960 at 22. I recall Kpebu says there has to be a second look at this because there's been a number of things happen. The law must respond to the exigencies of our time. Section 1, specific to the application of Part 1, where an arrangement has been made with any country. And that's what Honorable Apiakobi, you referenced, where an arrangement has been made with any country with respect to the surrender to that country of any fugitive criminals, the president by legislative instrument may order that this act shall apply in the case of that country, subject to such conditions, exceptions, and qualifications as may be specified in the order, and this part shall apply accordingly. Michael Kwe, Jr. Is there any question about the integrity of the extradition? Really?
Yes, thank you very much. Thank you very much. Greetings to everyone on the platform today, and especially the viewers. But my brother Eduji, don't worry. Just like our brother Amewu borrowed the seat in Hohoe, your sister has just borrowed the seat from the MPP for a bit, so don't worry. We shall come. Oh, let me make my point. When you spoke, I was quiet. I was quiet. You don't talk. We have also lent you the seat. We all know some of the internal issues that led to that matter. But I want to assure him that those internal issues have been resolved, and by the grace of God, we will take the seat back to continue to serve the people of Dome Kwabena. Rest assured. Now,